Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere to let the conference see the light of day again, and at the same time to show compassion and empathy in our community. Let's watch the launch and keynote address together.
Hello everyone, a very good morning from Malaysia. I'm Wailun.
I'm Hongkit. We are the founders of L2 Icon. It's our pleasure to welcome you to the Construction Claims and ADR Conference 2021. We are very honored to be able to work together with Legal Plus Malaysia, which is a very reputable and established conference organizer. Legal Plus Malaysia was founded by Tun Zaki Azmi, the current Chief Justice of the International Financial Court in Dubai, Tan Sri James Fong, retired Federal Court Judge, and Catherine, retired Executive Director of Bar Council Malaysia. A big thank you to Legal Plus Malaysia.
Besides, we would also like to express our gratitude to the distinguished moderators and speakers, as well as all the participants for joining and supporting this digital construction conference. It is our aim and vision to provide high-quality online conference with cross-border participation, covering the widest possible reach to the audience at very affordable price.
Yes, that's right. We also thank our sponsors, supporting organizations, and academic partners for their support. Without further ado, we now pass the mic to Tun Zaki to officially open the Construction Claims and ADR Conference 2021.
Ladies and gentlemen, please welcome Yang Berbahagia Tun Zaki Azmi.
Hi, ladies and gentlemen. Assalamualaikum, and a good morning, evening, afternoon, or night, depending on where you are now. Let me welcome you to the Construction Claims and ADR Conference 2021, which is jointly organized by the Legal Plus and L2 Icon. This is the first virtual international conference marathon of its kind, as far as I know. Conflicts and disputes are common in the construction industry, given the complexity of projects and involvement of various parties and trades within the construction chain. The current pandemic has aggravated its impact on construction projects, and industry players have been facing great financial and time constraint, as well as disputes contracting parties in a construction project's life cycle. Hence, dispute avoidance is the first step to dispute resolution. It is crucial for industrial players to be equipped with better management skills, a properly designed mechanism, a better understanding of construction contracts, and strengthen their project management skills. We have assembled a panel of moderators and speakers who are the cream of the crop of the respective fields in the construction of ADR communities around the globe to share their views and thoughts with us. Our conference today is an unconventional one. This is the first 12-hour virtual conference of its nature, and we are attempting to set a new record on the Malaysia Book of Records for the longest non-stop virtual construction claims and ADR conference. Now, not forgetting to give back to the community, we have waived registration fees for students from our academic partners to attend the conference. We are also proud to announce that we're collaborating with the Lighthouse Club of Kuala Lumpur to run Caring is Sharing 2.0, a laptop sponsorship charity drive for underprivileged primary and secondary school students within the construction community. Ladies and gentlemen, the ongoing COVID-19 pandemic has created many new challenges for each of us, but this should not be a reason for us to put our daily life on hold or stop us from connecting with our communities, our friends, and our colleagues. With that, I say thank you for being with us here today, and I hope you enjoy today's conference and find it beneficial to you. Thank you and have a good day. Thank you.
Thank you very much, Zaki. Ladies and gentlemen, the Construction Claims and ADR Conference 2021 has now been officially opened. I'm Azlan Jais, the first MC for today's conference. A quick introduction about this exciting conference. It has 33 distinguished speakers and 7 moderators coming from 9 different jurisdictions. There are Malaysia, Singapore, Brunei, China, Hong Kong, Australia, New Zealand, England, and United States of America. This is also the first ever international 12-hour marathon conference. And this is not a self-proclaimed statement. In fact, we are going to set an official record in the Malaysia Book of Records to be the longest non-stop virtual construction and ADR conference. Congratulations to all of you for being part of this official record. Remember, all participants are entitled to a free digital certificate of attendance on request basis after the conference, and the record will be stated on it. This conference cannot be held in this magnitude without the support of our partners and sponsors. I would like to thank our conference partners, Thomson Reuters and LexisNexis. Don't forget to collect the virtual door gifts from our conference partners at the virtual goodie bag. Also, a big thank to our session partners, Plus3 Consultants, Turner International, Opus 2, and James Montero. Next, we have our premium platform sponsors to thank: WCW Consulting Sdn Bhd, Stephen Tiru and Suda Partnership, L Consultants Limited, Tun Razak Exchange, Contract Solutions, BK Asia Pacific and Entrusty, Ravindran and Azmi Chambers, Harold and Lam Partnership, Halim Hong and Kwek, PMCC Corporation, Speedbrick, and 2C Consulting. We would also like to mention our food delivery partner On Bazaar, our bar partner The Bertie and Bella, and our FB partner Lavender Cafe by Lazat Cooking. Their involvement has enabled us to try to give a few features that are normally missing from virtual event. Thanks again for everyone's support. It is with great pleasure I now introduce our keynote speaker, Tan Sri Dato Cecil Abraham, who is the senior partner of Messrs. Cecil Abraham and Partners. He's one of the prominent lawyers of his generation and without a doubt, one of the leading names in Malaysia for construction claims and ADR. Without further ado, I now invite Tan Sri Dato Cecil Abraham to deliver his keynote address.
I would like to thank the conference organizers, Legal Plus Sdn Bhd and L2 Icon, for inviting me to give this keynote address. Historically, there is no authoritative or statutory definition of construction law. It is understood to mean the law dealing with all aspects of disputes pertaining to the construction industry. Construction law is essentially grounded in the law of contract. The early construction disputes were dealt with by the courts. However, as these disputes became more complex and technical, they evolved to be dealt in arbitrations mediations, expert determination, dispute boards, and adjudication. What does the present hold for us? The Arbitration Act 2005 was enacted to replace the antiquated 1952 Act. The 2005 Act brought confidence locally and internationally to the arbitration system in Malaysia. The notable cases decided pursuant to the Act will no doubt be discussed in this conference. The Construction Industry Payment and Adjudication Act 2012, CIPA, was enacted and came into force on the 15th of April 2014. And it has spawned a number of controversial decisions which will undoubtedly be discussed in this conference. As I said earlier, in the past, construction disputes were dealt with by the courts, and there were no specialist courts to deal with construction disputes. This has been remedied in that we now have specialist construction courts in Malaysia, and the first one was established on the 14th of April 2014 in Kuala Lumpur and Shah Alam, just one day before the CIPA came into force. What does the future hold for us? The COVID pandemic has brought the whole world to a halt, and the consequence of it being felt where construction works continue to be severely disrupted with the current EMCO in place. The government has introduced an act, which I will call the COVID Act 2020, on the 23rd of October 2020, and it will be interesting to see the impact or the relief that this act may provide to employers. I would briefly like to deal with one or two decisions of the Federal Court which deals with the impact of the Arbitration Act and the CIPA Act. In respect of CIPA, the Federal Court has put to rest on whether CIPA is to have a retrospective effect, and this was decided in the Eureka and the Jack in Pile decision. However, what the Federal Court did not do was to specifically say that the decision is to apply prospectively, so that it would not affect the provisions of CIPA in respect of decisions which had already been handed down in respect of CIPA contracts which had been entered into prior to the Act coming into force. As a result of this, applications are now being filed in the High Court to set aside CIPA awards. And one such decision has already been dealt with by the High Court and is presently on its way to the Court of Appeal. And I'm sure it will eventually end up in the Federal Court. And this is the Majlis Bandaran Kuantan decision. With regard to liquidated damages, the cubic electronics decision is being discussed in this conference. And the issue that arises is whether cubic, which is a decision under Section 75, would apply to construction contracts. There are a number of other decisions which I would like to very briefly deal with. One of it is the Far East Holdings case, as a result of which Section 42 of the Arbitration Act was amended and deleted from the Act. This was a very drastic step that was taken, and what should have been considered is to have a filter mechanism, as is the case in other jurisdictions. I understand that the Bar Council is proposing amendment to see that there is an amendment to have this filter mechanism so as to bring us in line with other decisions in countries such as Singapore and elsewhere. What is rather disturbing is a decision of the Federal Court in Pancaran Prima Sindrian Bahad where it was held that an arbitrator was allowed to rely on his own knowledge and expertise in arriving at a decision, and that this will not constitute a breach of natural justice. This decision is now being considered by the Bar Council Arbitration Committee, and I understand a proposal will be made to amend Section 37 to consider this particular decision as such. Coming back to SEPA, which has been in force since 2014, one of the drawbacks is this, that in the light of the decision in view as steam, it is possible now in a payment response for someone to raise new issues. For instance, an expert report could be served, giving the claimant only 5 days to address the issue. Attempts have been made to review the US team decision, but without success. I hope that the construction committee of the Bar Council will look into this and perhaps suggest amendments to the SEPA Act. Now, coming to the future as to whether litigation, arbitration, adjudication, and mediation, or what will be the best way forward, the answers may not be straightforward, as most construction disputes take into account, one, having specialist construction courts proving to be the most effective, time effective, with excellent judges in place. Arbitration is no longer cost effective, and as it is difficult to set aside awards, perhaps it provides some certainty. With regard to SEPA, the Act has really got to be looked at so that it gives parties more certainty with regard to SEPA awards and setting aside. Whether mediation may or may not be a factor, it will only be fruitful if parties are willing to sincerely mediate and not utilize it as an opportunity to delay a full and final resolution. I'm honored to deliver this keynote address for the beginning of this 12-hour virtual construction marathon, and I have no doubt that this will be beneficial to all those taking part, especially taking into account the very distinguished experts and speakers who are going to take part in this forum. Lastly, I would like to end by saying that I'm touched by the initiative taken by the organizers to donate laptops to students at this very difficult time. Thank you very much, ladies and gentlemen.
Thank you, Tan Sri Dato Cecil Abraham. Before we going to the next session, I must thank all our supporting organizations and academic partners for their support, without which we could not possibly reach such a wide crowd today. SEL Malaysia, SEL Law Australia, Master Builders Association Malaysia, RISM, AIADR, MIARP, CIARP, Malaysian Society of Adjudicators, UK Adjudicators, CABE Malaysia, CIOB, PAM, Lighthouse Club KL, Women in Construction Malaysia, KL Bar Malaysia, Sabah Law Society, China Asian Legal Cooperation Centre, Inns of Court Malaysia, the Honourable Society of Lincoln's Inn Alumni Malaysia, Malaysia Inner Temple Alumni Associations, the Malaysia Middle Temple Alumni Associations, the Malaysian chapter of the Honourable Society of Grace Inn, UITM Fakulti Seni Bina Perancangan dan Ukur, Taylor's Law School, University Sains Islam Malaysia, ATC, BAC, and Massey University of New Zealand. We are truly honoured, as I said earlier. Their support is very important and certainly adds prestige to our support.
During the conference, we launched a charitable initiative called Caring is Sharing 2.0. The funds collected helped purchase laptops for underprivileged primary and secondary school students whose parent works in the construction industry. It was this experience that became the spark for us wanting to help more people, not limited to only those in the construction industry. we approach charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. The opening session for the conference was a hot topic as it concerned pressing issues such as the extension of time as well as loss and expense claims arising from the COVID-19 pandemic. It is not surprising that at that point of time, our viewership reached an incredible 1,302 concurrent viewers. Let's watch those moments together again.
Good morning, honorable judges, panelists, distinguished guests, ladies and gentlemen. My name is Tan Hui Wen, and I will be one of your MCs for today's Construction Claims and ADR Conference. I would like to remind all participants that we will be running some polls throughout the conference. Please join us. It's now time for us to begin Session 1, Extension of Time and Loss and Expense Claims Arising from the COVID-19 Pandemic. Session 1 is proudly brought to you by our session partner, +3 Consultants. +3 is a company of professionals founded over 30 years ago to advise and assist organizations within multiple sectors, including the construction, engineering, energy, and infrastructure industries on complex commercial and contractual matters. We are honored to have with us Justice Dato Mary Lim as our moderator for Session 1. Justice Lim needs no introduction, but please allow me to share a short one. Justice Lim was the first judge of the Construction Court in Kuala Lumpur until her ladyship's elevation to the Court of Appeal. Justice Lim is now a judge of the Federal Court, the Apex Court of Malaysia. Ladies and gentlemen, please welcome Justice Dato Mary Lim.
Thank you, Hui Wen. Good morning, good afternoon, good evening, perhaps. Welcome and thank you very much for joining us this morning. I look at the number of participants, I see 1.2. It's not 1.5 persons, it's 1,200 participants. I've never had so many people in a hall. I've never had so many in the courtroom. It's totally impossible. It's only possible because of the pandemic. And this is why we're here this morning, ladies and gentlemen. First, to talk about the very problem that is very, very thorny. However, before we go down that road, there are 3 house rules. First, all questions, if any, please direct them to that chat group. But second house rule, please keep them simple. And the third house rule, please keep them short. I'm going to be multitasking, so it's absolutely difficult for me to read your long thoughts. So do keep them simple. I've got a very esteemed panel of panelists, and we are going to endeavor to address your concerns, your questions, etc. If they do not me, it's not intentional. Please do not despair. Please follow up and suggest to the organizers, perhaps we should have another session. We'll look at it. Right, this is session 1, and we bring you the issue that is the top of the pile as far as this pandemic is concerned, that's plagued the construction industry for the last 16 unfortunate months. The havoc that it's wreaked, and it's still wreaking. Work in the construction sites did not stop, didn't get anywhere. Completion dates seem to be a real impossibility. Nothing was and seems to be moving, especially except money, and it's going in the wrong direction as far as some of us are concerned. And it seems to be hemorrhaging for other reasons and at Olympic speeds. It's happening in Tokyo at the moment, ladies and gentlemen. It's happening, it's hemorrhaging for additional payments for tests, masks, sanitizers that none of you even thought of when you started to bid for any of these projects. So how should delay, expense, costs, and stuff like this be handled? Who's to be blamed? Because it didn't fit into your wildest dreams or intentions at the start or at any time, not even at law school. So who should be responsible? Well, when I got down to the original 3 distinguished members of this panel, namely the lawyers, that's Raj, Chris, Kevin, to explore how we were going to deal with this concern, we found that we perhaps may not have sufficient real data. So instead of trying to speculate and try to cite from the industry players, a wonderful plan came, and we decided to bring the men themselves, Mr. Oliver Wee and Dato Som. These people will tell us exactly what's happening vis-a-vis delay and the costs. I'm not going to go into detail as far as their careers and their achievements are concerned. Google them. I tell you, you will spend the whole day reading about their achievements. So I'm going to go straight into it. But just before we do that, ladies and gentlemen, we're going to do a poll. We will do the first poll of the day. And the question is very simple. Can I have the organizers put it up? And this is it. Simple. Who should be responsible for delay and additional costs during this COVID-19 pandemic? We're going to give you a multiple choice question, just like going back to school, but only 3, and you can only mark 1. Should it be contractors, employers, government? Only 1. We will keep this poll open for 5 minutes, and we will see what your thoughts are. There are 1,200 of you out there. Please take part. And with that, I am going to go straight into the session itself, and there are 3 parts to it. We will deal first with delay and disruption. Secondly, we will deal with the extensions. And then 3, we're going to see what we're going to do going forward. Right, very first question. And that is going to be this matter of this COVID-19 pandemic. Caused delay. You know, everyone's talking about it. Has it caused delay or disrupted work? Your thoughts first, Raj.
Yeah, of course, the COVID has initially caused delay because initially there was a total lockdown last year. And then when, I'm talking about Malaysia now, when we actually allowed the construction sector to open, there were many restrictions in the standard operating procedures or SOPs. For example, people had to go testing, they had temperatures to be taken, social distancing on the construction site, although I don't know how that was going to be achieved, many of these things. So that would obviously have reduced productivity, and that would be more in the nature of a disruption type situation. Yes, I think you have to look at it in 2 segments. The first, total delay. Second, disruption and loss of productivity. Right,
thanks. Kevin, do you share those views, Kevin?
Absolutely. And what really is surprising is the breadth and the extent of, I'm going to use this term, damage that COVID and the pandemic has caused. It's not just a question of impeding the ability of a contractor to do work, but it's completely hit balance sheets and cash flow quite badly. Supply chains are in trouble. They're breaking. it's unsure when a contractor can even get materials if they are sourcing the materials both locally or from abroad. And we have all these other labor and worker situations that we're having, which is causing so much uncertainty at the work site, including daily testing, weekly testing, who is going to bear the costs of these tests, of the testing. And clearly what's paramount are the workers' health and safety at site. And how to deal with all these problems that are coming and just does not seem to be abating. There's really no clear answer at this point, at least, and everyone is still trying to find a footing, and hopefully we'll come to some landing soon.
Okay, Chris, is it the same over in Hong Kong?
Yes, Judge. I think in terms of delay, that in terms of private sector, like properties and all that, there's roughly 6 to 12 months delay in completion of works due to materials, as Kevin mentioned. And on top of that, there is basically a shortage of labor because, construction sites tend to be, for example, closed off. People have to get tested, they have to get vaccinated and so forth. So there's a delay relating to that as well. I don't think we have any concrete data in terms of scientific data that's been analyzed. But yesterday I saw on the internet, a UK consultancy firm did do a survey, and they found that three quarters of those surveys say that the COVID is in fact causing delays as well as cost to the construction industry, and which basically they need to address going forward. And so that is a concern in UK. So I think if UK has it, I'm sure Hong Kong has it, but we don't have any data as of yet.
I see. All right. So the three lawyers have told us real concerns, and it looks like we may not still have turned the corner. So let's turn to the people on the ground. Oliver, what do you think? Do you tell us what's happening on the ground, please, Oliver?
Yeah, thanks, Judge. Yeah, indeed, definitely, without a doubt, the delay which is faced by the industry. Now, the government has, through various National Security Council announcements, informed the industry only the essential services were allowed during the MCOs. And the construction industry not only experienced the direct stoppage from such restriction, but also affected by the disruption from supply chain, be it locally or overseas. Now, in addition, compliance to the SOP has tremendously reduced the productivity on site during the period at which we were allowed to work, that was within the MCO's time. In short, since March 18 last year until today, 491 days, MCO 1, 2, and 3, together with NRP and so on, has taken away 174 days. And this day, no work were allowed as construction were not actually classified as essential service, but the balance of 317 days, contractors were just burning money away for extremely low productivity with much mitigation cost incurred. We are actually recording a productivity as low as probably 40% in general. That's what we are facing, Judge.
So you now use the term you're burning money, and I was talking about it hemorrhaging. It looks like about one third of days, costs, etc. So 3/4 going the other way. Dato, you have heard the 4 earlier on. Is it better at your level?
No, thank you, Judge. I think we are no better as a client, as you're aware, because the contractors are like one of our enablers. So if they are badly affected, definitely we are also affected as well, both in terms of cash flow and like what Chris has mentioned, the dimension on the supply chain, labor. And also here we have another dimension, which is actually because government offices are also closed. So there are a lot of things that we can't even get through or get approvals. That's one of the major barriers for us as well. And as mentioned by Oliver, productivity is very, very low. In some cases, if there are recurrence of cases at the site, there'll be a closure again and the restarting. And also because of cross-border supply chain, we have a lot of issues happening in other jurisdictions that actually was not taken into account. And in Malaysia, the biggest problem we are facing today is actually labor. So with no political will to resolve this matter, situation are deteriorating by the day.
Oh dear. Oh, I'm getting from you, Dato Som, that employers are also in the same boat, and the problem is not just localized, but extensive, and what's happening in other jurisdictions has its cascading effect on us at the same time. And you mentioned about the lack of political will, and the fact that we seem to be totally or still hugely reliant on labor. Perhaps we should be looking at new methods. But just before we go down that road, two of you earlier just mentioned about the fact that we had 3 MCOs and we've got various other orders. Kevin, is there any difference between the different control orders that have been issued? Should we look at things differently, because there's some legislation involved, isn't it? At least 2 major legislations. Some thoughts on this first, please.
Yes, absolutely. In fact, to all the contractors who are here today, I think it's extremely important for us to identify and understand which movement control order, in fact, affected your work or your ability or inability to carry out your work. And I think that is quite amplified in our COVID Act, our temporary measures for reducing the impact of the coronavirus disease 2019 Act, which we call the COVID Act. And the importance of understanding these measures is amplified in Section 7, which is a star of the Act, which says that, which speaks of the inability of a party or parties to perform any contractual obligation arising from the categories of contracts. In our case, the construction contract must be due to the measures prescribed, made or taken under the Prevention and Control of Infectious Diseases Act. It's not carte blanche. We can't go, or rather, a contractor cannot go to an employer to say, look, COVID has hit me hard. I am struggling financially, and I'm therefore relying on Section 7. It doesn't work that way. A contractor must anchor the inability to do the work to a particular movement control order. Now, we've had 3 large or widespread orders, and we've had a whole hodgepodge of all sorts of other kinds of orders, from the FMCO to the MCOs. But the 3 main ones were, the first one was in March of 2020, which was extended until sometime in April of last year. The second one was earlier this year. I think it was from the 13th of January until sometime the 16th of February. And we are in the middle, hopefully in the tail end of our third one. But all of these movement control orders have different characteristics. The first one was quite clear. It was a complete total lockdown. Everything was shut down to a point that everyone knew they could not step out of their homes. And it was across the board throughout the entire country. And then we had a lot of these mini FMCOs and CMCOs. One of them was, I think, on the 26th of October of last year, which really was, didn't really work because the offices were full and the roads were full. No one really complied with that particular CMCO or FMCO, what have you, at that point of time. But then we had the other one, which is sometime earlier this year, which was in January. Now, the one in January is quite different because the one in January was area focused. It was not, did not cover the entire country. It affected particular states, sometimes even particular districts or inter-districts within a state. So a contractor who would like to apply, or rather rely on Section 7, or apply for EOT, for example, must specify which particular order or measure that was taken under the Prevention and Control of Infectious Diseases Act 1988, which prevented that contractor's ability or inability to carry out his or her work. Now, that really, this is not criticism of the Act itself. This is how it's framed. It is applicable within a very narrow band. But it's not necessarily wrong or bad, because let's assume that we do not have this Act, but these measures and these movement controls were in place. Anyway, you'd still be applying for EOT based on these movement control orders that have been hitting us from the first quarter of last year anyway. And you would not, and I say so respectfully, of course, you would not find a charitable or a warm contract administrator who will say, look, thank you very much for giving me notice, and I'm going to give you extra time. A contractor must still specify and particularize which event exactly impeded your
For you, Kevin. So therefore, you're talking about the fact that we now need to specify Raj. It would appear, having heard Oliver and Dato, the problem, the magnitude is just quite beyond our previous experiences or experiences to date. Records, keeping of records appear now to be quite important. What say you, Raj? And is there a need? We heard from Chris just now about how Hong Kong distinguishes between public and private contracts. But let's deal with the recording, maintenance of records now for all these problems. Are we, it's 16 months since, are some of us going to be too late in finding records?
Well, any kind of claim is document sensitive. I mean, in the sense that you always need to have good record keeping. The problem is people are trying to survive right now. I think their priorities are less on keeping records and making a claim later, but just keeping their head above water. So I'm not sure that when they eventually get round to wanting to make a claim, whether record keeping would be, they would have had decent record keeping. I wouldn't know, but I would think that probably somebody like Oliver might be in a better position to answer the question.
Okay. But just before we go down to Oliver, Chris, you mentioned that Hong Kong makes a distinction between public and private contracts. You heard what Oliver and Dato shared, and warnings by Kevin about our star provision in Section 7, our local act. I'm not sure if you had an opportunity to look at it. Is there similar treatment in Hong Kong? Legislative intervention?
Judge, I don't think we have
issues.
I don't think we have similar treatment in Hong Kong, similar to Malaysia. But as you mentioned early on, we tend to actually focus on the private sector contracts and also the public sector contracts. Now, take, for example, there are many private sector forms of contract. Take, for example, the 2005 private form. There are certain provisions like clause 25, 26, 27, 28. They all relate to time, recovery, expenses. But these types of contract, the private form, you can actually only claim time. But the key thing here is you need to notify the project manager. If you don't notify the project manager in the right time, you lose your claim. Now, unlike public contracts in Hong Kong, I'll just look at one example. The government has adopted NEC. I'll not make a comparison between 3 and 4. I'll just look at one of them. Under NEC clause 60.1, subparagraph 19, they do have provisions that cater for time and cost. So you can see the distinction there in terms of public and private sector. Now, if you look more in the Pan-Asia Pacific, where lots of contracts are done through FIDIC, if you look at FIDIC in terms of clause 19.1, I'm looking at, for example, the 1999 edition of FIDIC, you can see that, for example, they only look at, for example, time, but not cost. So you can see that, for example, in terms of private and public, there are certain differentiations. And in the public sector, our government in Hong Kong is pretty supportive in terms of giving sort of compensation events, in terms of, for example, extending projects, release of sort of payments and so forth at a timely manner. Previously used to be 1 month, 30 days, but it's now within 1 week or even 2 weeks the most in terms of money upfront, and also down payments in terms of those milestone payments. And what happens, you have a bigger lump sum at the very beginning, and hopefully to get you moving forward. So I think that's very important. And I think they took that emphasis from, I think last year, UK government, the cabinet issued some kind of note. I remember what they said. I think I'll just remember. They said we are all responsible in our community, and that we have to work hand in hand to make sure that everything is done on a fair and equal basis. So we need to share risks. So that's what someone from the Cabinet Office of UK said about construction.
Right, thanks. We have stopped that poll for the moment, and we will look at the results shortly. But let's just work on some of these problems. Going back to what Oliver mentioned, you were talking about, it's so important, the working hand in hand, and then as little as possible difference between public and private contracts, perhaps. But there seems to be a lack of coordination, Oliver. You were talking, and so was Dato earlier, about the delay, and you had localized problems. What kind of local problems did you have, Oliver? What are your members? What kind of problems did your members have?
Well, I think the immediate problem is funding, the money. That is very basic for all the contractors. Well, other than that, I think a lot extra that we have to incur, that which no one has actually budgeted for all these unplanned events. Well, just to name a few, contractor now need to have extra labor force, 25 to 30%. It's just because the job site is not allowed to have too many workers at one go. Whenever you are allowed to work in order to comply to the SOP. And therefore, we need extra labor to work on staggered hours in order to maintain our schedule. In terms of nominate subcontractors, most of them are not even allowed to work because NSC workers are working on few job sites at one go most of the time. And not unlike main contractor workers who are only stationed in one job site. And this is also one of the ways we actually try to prevent NSC workers bringing virus from the other side. So NSC also be hit in this way. Shortage of labor definitely.
Funding, labor. What about materials?
Yeah, sorry. Material, yes. The supply chain. Sorry.
Is it easy to source materials, both imported and the local ones?
Both are difficult. Basically, manufacturer also not essential service, and therefore their lead times are actually under our liabilities. For example, if we are allowed to start work now, we need to wait days or even weeks before the supply chain is stabilized. Moreover, idling of machineries, plant, is all the fixed cost for no productivity, no progress at all for the past month. And in addition to that, like what Dato Soman say, extra costs that we have incurred for our workers, frequent testings, quarantine costs for those workers who were infected, the close contact, of course, sometimes frequent stop work order by the authorities, and many more. Disinfection costs. Last but not least is the vaccine cost that is coming up for all our workers as well.
That didn't factor in at all at any time, isn't it?
Absolutely not. Yeah.
You heard what Chris said. Do you think you'll fit in under FIDIC, the FIDIC clauses?
Or I'm not pretty too sure on that.
Raj, what do you think, Raj? Who should be responsible then? Who should be responsible after listening to the some idea of the magnitude of the problem caused by COVID in so many ways? Raj, who in your esteemed view ought to bear responsibility for delay and costs?
Ideally, it should be the government, but that would depend on whether the government has the means. I wanted to maybe circle back a bit to what Chris said, because I think we have been looking at it very much from the perspective of private contracts. But I think we are missing something here, because under our government contracts, the government has actually issued a circular basically recommending that, and the circular is on the 23rd of June 2021, and it talks about extensions of time.
This is a circular issued by Treasury?
Yes, it is issued by the Ketua Pengarah Kerja Raya, that's the Director General of Works. And it is addressed to all the JKR officers. You see, so there is a recommendation, or at least that they are allowed to give extensions of time if it's caused by the movement control orders, but it is limited to 60 days. Right now, in terms of time, as I said, that is basically how the government contracts are addressed. But coming back to what I said earlier on, if we look at how Singapore has addressed the problem, if I may, they have last year they had an automatic extension of time of 122 days. If you could show that it was caused by for contracts which were entered into before the control orders came into place and due to certain other restrictions. So it makes things a lot easier because, you know, there is a blanket extension and automatic extension of time, whether or not it's in the contract or not. So in a way, the government has stepped in to kind of mediate the risk, so to speak, taken by the contractor. We're not talking about cost now, but we'll talk about it later. And then maybe we, as far as time is concerned, I think to summarize, in Malaysia, there is also a distinction between the private and public sectors, and the public sectors are one step better than the private sectors because there's been a recommendation for extensions of time. In other jurisdictions like Singapore, there is an automatic extension of time for all contracts.
Right. So our neighbors seem to be doing it differently. Questions have come up from the chat group. Thank you for those questions. I may not mention your name, but one relates to purchasers, house buyers. Many of us can relate to that. COVID Act makes provision on that, isn't it, Dato Som? And what is the Building Industry President's Council got to say about this?
Okay, as early as May last year, in 2020, in fact, just after the MCO was imposed, in the month of April, I think REDA did issue a statement to tell the government that they need to come up with to enact a COVID bill to resolve this matter. And in a couple of meetings in Putrajaya, I still remember in April, we told the minister in charge of economy at that time that this issue must be addressed. And that's where the circular from the Director General of Works came out in relation to government contracts, where you limit the EOT to 60 days. But you know, as time goes on, there was serious delay in us enacting the act. We all know the reason why. And because of that, and also the various movement control order, we know that there will be a lot of legal ramification arising out the management of the contract. And then the Presidential Council of the industry players issued a joint statement in November after the COVID bill was enacted and published. We felt that there were a lot of shortfall there in that act. And then we asked all the parties concerned to exercise care to look at the bigger picture of ongoing contracts on what we should do, and also projects that are seriously affected by the PCID, the prevention of infectious diseases. They are also contracts that are actually affected way before the 18th of March. So for those, I think it has to be treated differently. And we were even advocating that the government should actually, like our neighbor, specify the number of days of extension to be given to contractors. Given that under Section 11 of the COVID Act 829, Act 829 did exclude a certain number of days on the delivery period for the developers, especially which relates to delivery time frame. And the other thing is that most of the private contract, especially development, are under, we are using the PAM form of contract, whether it's 2006 or 2018. And it's quite clear that pandemic or epidemic mentioned there did say that, like what Chris earlier mentioned, that in Hong Kong. Similarly here is if it's a force majeure event, as stated in the contract, then there is actually time to be given, but with no cost. We even asked that maybe the administrator of the contract, especially the architects and the SO, be a bit more lenient, because the whole COVID Act talks about obligation. It doesn't talk about the right. So some of them may have forgotten to actually, send in notices on time. So we are asking the administrator to even forego or just don't look at that. And then
all right, Dato Som, that one you are just hold on before we get to that particular topic on the extensions. I hear your plea, but it looks like we've got a remark as far as the Treasury note and the DG of Works note on the 122 days. One of our participants has just pointed out that that's actually specifically government, and it is what Dato just touched on, HDA contractors, HDA contracts. So far we've got on the ground huge problem, lack of coordination, and distinction between the different contracts, and the action and reaction seems to be piecemeal. Let's not forget the COVID Act is only for 2 years. Time seems to be running out. There are extension provisions, but I'll let you guys talk about it. Can we just, before we then move to the next part of our thoughts here, just have a read of what the poll results are like. Cindy, can we have it on the screen here, Wayman, please? What the poll results tell us. There you go. The issue is, as we said, who should be responsible? I hear remarks that you can mark all three, but the government is very popular. It's an extremely popular choice. Are we surprised? Good reasons. No. You're not surprised, but there are at least 24% who feel that it should go to the contractors, and there are 41% who feel that it must be borne by the employers. And I think there must be valid reasons for it. So let's move to the next part of what we are talking about, and that, with the extensions, with the magnitude of problems, people have to apply for extensions. Legislation hasn't really intervened to the extent that extensions are automatic. There are provisions about how it's to be handled, as Kevin cautioned. So, looking at the last 16 months, has COVID-19 become or has surpassed all reasons or causes for delay in EOT applications? Can I come to you, Chris, sitting as arbitrator?
Judge, yeah, I think in terms of cases coming to us, I think COVID does play a significant part in terms of...
Sorry?
COVID does play a significant part in terms of EOT extensions, claims. But of course, there are many players in the market are waiting to see how certain things develop, either in courts or in arbitration, so that they can actually claim or put forward claims. Because it's now they're testing the water to see, for example, whether certain arbitrators or certain judges are going to be looking towards one player over another player. And I think if you do that, there could be risks. As I said early on, most contracts do have notification periods and all that stuff. So I think you really need to gather your documentation, as Kevin and Raj said early on. Documentation is important. You have to make sure that everything's been notified in accordance with the contract. I remember that there was one report last year done by a consultant in Europe that said, for example, that most people do not really understand the contracts, or they forget to implement certain provisions because they're too busy trying to get the work done. And I think with COVID now, I think it's very important that you actually jot down all the milestones, all the things you need to report, all the precautions and so forth. Now, could I just go back to that survey, just to give you some flavor here. Now, most people judge, when there's crisis, most people believe that the first person they have to actually blame is the government. Now, the government is responsible for everything. I think that is the key. I think we did the survey in a way to get more attention from the audience. And I think the key thing here, as I mentioned earlier on, I think if you don't have the other players in place, like the suppliers, the contractors, and you don't work with them, the chances are your whole supply chain is going to have a problem, and you can't deliver your product to the intended customer. So my feeling is, this is a situation whereby we never predicted it. We prepared for the worst in terms of construction, in terms of explosions and all that stuff. A pandemic, I think this is the first in the world whereby everyone's affected. So I think the key thing here is, learning from this is, we can't simply just blame everyone. Okay, if we follow the contracts exactly word for word, the chances that one person will win over another person. But the key thing is, we have to be fair and to make sure the supply chain moves forward. So that's my point, Judge.
Right, so that's arbitrator talking. Raj, as counsel, have you seen your clients coming to you offering COVID as the cause, only cause for EOT applications? Speaking as counsel.
Strangely enough, as counsel, we've had very few people coming to us here at the moment, and I think it's only been brought up by us sometimes when we're trying to defend someone or do something. But I suspect, and Oliver can probably confirm whether my feeling is correct, that they have more important things in their mind at the moment than to start, to consult lawyers and to invest money in legal fees and fight with the employer. But I want to also highlight something again. Like I seem to be leaning towards what's happening in Singapore, and it actually, in a way, reflects the poll, because we say, why should the government bear it, right? And here's a quote from the Minister for National Development in Singapore, a gentleman called Desmond Lee, and he told Parliament when they were proposing an amendment to the Singapore's COVID-19 Temporary Measures Act to make sure that no single stakeholder group in the construction industry bears an undue share of the burden. He said that construction projects could be put at risk if one party, and this is a very important phrase, along interlocking contractual value chains fail. So it's in the government's interest, because the thing is, you can't say, contractor, if you fail, it's going to help the country, because the government has to look at the big picture, the holistic view of the whole interlocking chain, and make sure that the risk is not unduly borne by any particular sector. And I said, to the extent that the government can help in terms of actual hard financial help, really depends on the means of the government. So I think in Singapore, they're obviously quite well endowed. We're not so well endowed. So that's why
we'll swing back to that instead of Oliver. Unless, Oliver, you want to deal with it right now? Those views of Raj?
Yeah, I think Raj is share quite a true view. I think many contractor has actually so-called sent in their application, whether within time or not. Contractor definitely not taking any serious action now. Like what Raj said, we probably have to reserve our money for other better use. Because the construction industry, the cash flow is basically you have no cash flow for the last 1 year. And we can't finance our operation by cash flow or by capital. We must have a cash flow. So I think contractor has done what they need to do by serving notice and waiting for the client to look into it, to discuss over it amicably.
And client, Dato So, what are you doing with that notice that's been served?
Okay, I think this we need.
Are you going to the lawyers as well?
No. I think we need to go back to PAM Practice Note 3, 2020, issued on the 18th of December. I think maybe a lot of the client or the contractors do not have access. It's only available to to the architect and also the SO. And that practice note, I think, clearly define what the contract administrator should do in terms of granting time for the contract based on the PAM form of contract. And I think it's very fair. It's a very fair practice note that I think a lot of the architects or the SO need to look at, because sometimes in a contract, to be fair, they are probably swayed by the client in certain instances. But here, I think we have a bigger issue at hand. And going back to Raj, I want to just go back to Raj, looking at the Singapore issue. But in Malaysia, I'm not so sure, given like what Kevin mentioned earlier, the Movement Control Order 2 and 3, and the FMCO, the NRP and all this, whether the COVID Bill 829 enacted last year is still good enough. I believe it's not. So whatever in Section 11 of the Act may not cover for any more additional time to be given to the client or the developers to complete their work. So I think it's an issue that we have to address later, but please look back at the PAM Practice Note 3, which, that the contract administrators should actually look at.
Thanks very much, Dato. So, in fact, architect Anthony Lee has immediately flashed it up on the chat. So anyone who wants it, please follow Anthony's chat. So still going by my question about whether COVID has surpassed all other causes for delay, what's the look like in adjudication claims, Kevin?
It is, I don't see parties rushing at this point to launch formal proceedings in adjudication or arbitration or even court proceedings at this point in time. I think there was some tension earlier on in the middle of last year, but I think both sides have settled down because both sides seem to understand and realize right now that if both parties are going to push strict contractual rights, neither party might come out of this hole. So I am currently working on one matter, which will go to adjudication, but that is only after a considerable negotiation between both parties. So that, I think, is the attitude that contractor and employers are taking on right now. They'll try their very best to see if they can come up with an amicable solution, and adjudication appears right now, at least from my experience, appears to be the last resort.
I see. So the clients are not coming here, coming to you for formal redress yet.
They are, but the overriding aim right now is to see if they can resolve these disputes. Without...
We will come back. We will come back to that note because I think that's prevalent as far as all 5 reviews are concerned. Raj, you were about to say something.
Yes, Judge. Yesterday there was this MIR conference, and Michelle Sunita from the AIAC, she's the head of legal, and she gave us a very interesting insight. I mean, this is just by the way, it wasn't in the formal talk, but she said yesterday was the first day she went back to work, and she was expecting to find a deluge of payment claims or adjudication claims to process, and she was surprised that there were very, very few or none. I'm not sure what she said, but it actually consistent with what we feel, that at the moment, I think contractors are not really thinking about legal remedies. I think they're more concerned with how to best spend their meager cash flow on keeping themselves alive.
Exactly what Oliver just remarked just now. But I think while the notices have to be sent and have been sent, I think what's important for our participants is to know whether they are being handled timeously. Are the SOs, architects, whoever has to make decisions on this, would anybody like to share their experience on this? Are they being handled timeously? Because, you know, no point telling us that, telling our friends out there, put in your notices for extensions, but nobody's making any decisions. So are decisions being made, difficult decisions, hard decisions, are they being made? And if they are being made, you know, if you're requesting for 122 days, which seems to be or the number that Oliver talked about, 491 days, and or 317 days, whichever number of days, are they being acceded to by the powers that be, the contract administrators? Dato, tell us.
I think it's very clear that contractors are not taking the legal route now because it's going to be costly and they're trying to conserve their cash flow. Second is, I think they're also quite sure that from the PAM form of contract, they would have been advised accordingly what are the contractors entitled to and what are not. And one of the biggest issues is actually the timely processing of the application for extension of time. And it's quite clear that under the PAM form of contract, contractors are actually entitled. But sometimes it falls back onto the contract administrator. And based on the PAM, practice note, it's very clear that they need to actually address the issue very quickly. And because under the COVID bill, developers or the client are actually given 167 days exclusion from the delivery period to the buyers. So I believe if the contracts are not further delayed, due to other reasons, clients would agree to give this extension of time. That's why we have told the government to amend this COVID bill very quickly, which they didn't do. Like in Singapore, it's very clearly stated that contractors are entitled to 120 days, which is for 4 months. So in Malaysia, we are telling, in fact, in our submission to the authorities, we have submitted many times, okay, to various ministers, and we have told the government that you need to give some form of a definite time frame to contractors, given that certain period has been excluded. I think we want to be very fair in this instance, and if there are contract dispute due to non-PCID, then it shouldn't be covered under what is in the COVID Act. So for contract administrators who are not processing it quick, I think you have no space in this business. You know, you need to make decision and make decision.
Right. We hear you, and I hope the contract administrators out there who are not abiding by your own industry standards, please heed them. There's no space. So there's 167 days. I mean, first, I think the remark that we need to take heed of is there's legislative intervention here. That means the 167 days is a given.
18th of March is from 18th of March to 31st of August 2020.
All right. So while the government doesn't seem to be working forward, it seems to be patching up the gaps, because that's how the COVID Act was, isn't it?
Okay, but just the concern is because now the MCO has gone beyond that in 2021. Okay, that act is as good as in 2020, MCO 1.0. So that exclusion period is only up to August. What about currently?
I think that also, if you look at the tone of the legislation, they do catch up. They do catch up, just like what happens. They patch the gaps. I think the most important thing is, and they've already anticipated there will be extensions, there may be extensions. But that's for another question that we will deal with later. Oliver, you heard what Dato Som has said, that he's reminding the contract administrators to handle these applications timeously. Are they keeping their word, Oliver?
I so admire Dato Som's contractors who has a good client. But actually, I think many contractor wrote, and what we got back is fine. We have acknowledgement of receipt of claim for time. Some of them got some EOT granted, but not conclusive. Simply just to replace one-to-one. Disruption delay can't be replaced under this sort of arrangement. The most scary one is what we receive is do first, we talk it later.
Oh dear. I thought those were old, I thought that was old days, and they tend to be the other type of contracts.
Yeah, the trick still works, Judge.
I see. Most scary is do now, and there's a record of that, is that?
Right.
I see. Right. So it doesn't appear to be full periods being granted. I think it's important to maybe pause for a little while. This is now July 2021. We've had 16 months of COVID. Can anyone tell and share with the participants, this time last year, how were the EOT applications being handled? Was it better?
I think it's the same. I think there are some good players, and I'm just looking at from Hong Kong. There's some good players here, like employers and developers and all that. They're very helpful. They're quite willing to actually give some extensions. But there's some who basically do not follow strictly by the rules in the contract. So there are many basically that have been rejected last year and this year as well. So what we're trying to do now, we're trying to find other means rather than actually go through the legal means. We're trying to find other means of actually sitting down with these players and employers and developers to see how we can actually work in a sort of a sharing process. And maybe I'll share that in a few minutes relating to what I've been doing with a particular contractor and developer.
Kevin, any views?
I think it's a bit better this year compared to last year. There was so much of uncertainty. Parties were holding on very tightly to the strict rights last year. But we've all come to to realize that holding on to strict rights is just not going to move anything forward. I see this year at least, employers are more, well, they are better when it comes to considering applications for EOT. They understand that if they insist on strict rights, contractors are just going to fall away and the entire project is going to fall apart. The only thing that I see still being a problem is while they are agreeable normally now to EOT, there's still a question as to who's going to bear the costs. They are not insisting on LAD, but still the question of the costs and all those costs that Oliver mentioned just now, the defensive costs, the mitigation costs, COVID tests, someone has to bear it at some point of time, because right now all of those costs are being advanced by the contractor or the subcontractor, none of which was priced into the contracts before the 18th of March of last year. So EOT, I think, seems to be better now, but the question as to costs and who will bear them is still, I think, a bit up in the air.
Raj, do you share Kevin's views?
I would say so. The thing is, that's looking at it purely from, assuming that we are looking at it from an extension of time under a force majeure type provision and possibly no cost, loss and expense. But we think that there may be some room for the employer to bear the cost if it is treated as a variation under the terms, particular terms of the contract. I mean, under PAM, Clause 11D talks about variations which include any limitation in working hours, working space, access to or utilization of any specific part of the site, execution and completion of works in any specific order. So it arguably could form the basis of a variation. FIDIC Red as well talks about the changes to the sequence and timing of the execution of the works. So it could be framed as a variation, and interestingly enough, if it's a variation, it may also qualify for time and money. Not yet tested, but possible. So I think employers have to tread carefully if they just say, going by the book, I don't give you any extension of time, because you might get hit with a variation claim.
I see. All right, very interesting route. But there is a question from Nick Sunderland that when you look at the PAM 23.1, you are supposed to indicate when the end of this course is going to be. Given COVID, can you actually write a date in? So how are these applications for extensions going to be handled then? Chris, how have the Hong Kong CAs been handling this issue?
I think that they've been trying to lobby the government to see whether, for example, there could be some flexibility, and I think they're getting there, but it's going to be a long road. I'll give you an example of what I'm doing now, rather than wait for the government or any other parties to get it to do things. I'm working with a contractor, liaising with a developer. Contractor is a very reputable contractor, and they do work very good. And they have an issue, and they've applied for EOT. The architect has rejected the EOT claim outright, gave a lot of reasons. The next course would be to actually wait until the project's finished before you actually instigate arbitration. The contractor is basically can't wait because they have umpteen projects. Cash flow is a big issue. They have a lot of employees. So we're now liaising with this developer to see whether we could actually instigate some form of mediation. And we've done that, and we've appointed a mediator. And hopefully we are now moving towards a solution whereby both parties can share the risk going forward. So in a way, if you wait for regulations, if you wait for government, not because the government's not doing anything, Hong Kong, our government, and I know in Malaysia, government's very proactive in the system. It's just that you have a bigger population in Malaysia and lots of other projects as well. But if you wait, it takes time. And also this money is public money. It's not government's own money. So they have to be very sensitive in terms of how they handle the money, because if they give it to contractors or developers, then the other people will say, what about us? What about customers of shops or these sort of other entities? So I think that they're trying to find a balance and mix. So that's why we're not waiting to actually for the government in terms of guidance. We're just going to go ahead and see whether we can actually work together. And so far things have been working, and this developer is not one-sided. they're quite willing to work because they know that if my client goes out of business, the chances are he might not have many contractors to choose from to actually fulfill his other projects going forward in the years to come. So I think that's a key that the developer realizes.
Right. That seems timely for us to move into the third part of our session. With the contract administrators now making decisions or reminded to make their decisions timeously, taking the concerns that have been shared by all and looking at experiences from other jurisdictions, does this mean that when we turn the corner, hopefully it's soon, will there be an increase in litigation, arbitration, and mediation at all? Raj, just looking at Chris's experience, his client's experience, and the warning that at the end of the day, if we all do this wait and see and turn to the government for solutions, it's still public money. Is it now back to the clients, back to the parties themselves? Should they be turning to litigation, arbitration, adjudication, or perhaps something else?
Well, I think certainly not the confrontational types of dispute resolution. I think even if it is adjudication, it is going to invest. It's going to require an investment in costs, which I think a contractor can ill afford at this moment. So too with arbitration. Arbitration is completely out of the question because the time it takes and the cost that you have to pour into it, really don't justify this. And in fact, interestingly enough, I think a lot of parties are actually settling, bad settlements perhaps, but at least settling to generate some cash flow. We've had one experience fairly recently where one party actually, on the receipt of a payment claim, they just paid something less, and the other party just accepted it and got on with life. So at the moment, it's all about survival. But I wouldn't discount the possibility that when all this is over, there may be a flurry of claims. And from the employer's point of view, as I said, it might be prudent for them to work together with the contractor and close out this risk, so that at least you end up with an equitable sharing of the costs now, and close out the risk of a major claim where you might end up by picking up the whole cost on the terms of the contract. Because like I said, there are avenues under PAM, under FIDIC, maybe not so much under the JKR form, but these are the most commonly used forms. At least PAM is here in the building industry, and FIDIC for the infrastructure works, especially if it involves a foreign party. And I think there is potential for claims later, but not now.
You just touched on the PW contracts. A question has come up from one of the participants. Would the situation be any different on how we treat, all our responses so far? Would it be different when we're dealing with PWD contracts, the JKR contracts?
I think it is for a number of reasons. I mean, not so much because of the particular provisions of the contract, although there are some important differences like the definition of force majeure and whether or not something like this would qualify as a variation, to be honest. But I think it's more to do with the fact that the government is able to take a more proactive role through the JKR or the Works Ministry to actually help the contractors or down the supply chain, and they are doing that. So there is really going to be a difference in what comes out at the end, because I think the government contractors are more likely to get immediate relief, but not so much in the private sector.
Oliver, Raj, Chris have spoken about this. Do you confirm that you will be not rushing to litigation and arbitration, or even adjudication?
Well, definitely not. I think contractor will never rush to that extent. We still hoping to resolve all issues with the client amicably, and mitigate our damages to the very, very minimum. That's what we're looking for.
Let's see. And Dato So, you share that view, please?
Yeah, I agree. I think we should, resolve things amicably. And if any parties, if it's an ongoing contract, any parties that walk out is going to have serious implication to the ultimate aim of the project owner. So I think we have, that's why I said that in the Presidential Council release, we actually asked all the parties concerned to sit down and actually achieve some sort of consensus as to what's the best way going forward. But between Oliver and myself, we are concerned about the people in the legal fraternity who will be giving false hope to contractors to claim against the client. I think this something that's getting more and more serious as days go by, and also maybe because of things which are not clear, and also because of the COVID Act is only good for 2020. Events in 2021 are not covered. So sometimes developers are a bit slow in reacting, because you see, the last year, this time, we didn't have the COVID Act. So no developers want to grant any EOT to their client. Okay. And then in this year, they already know that they got the 167 days. So they become more sure so that they can give extension of time. But for event that happened in 2021, they are not sure whether government is going to make any amendment or changes to it. So they are also still not sure. But we are still trying to tell all the industry players, please sit down, discuss, and come to a resolution. I used to wear both hats. I am a contractor and a developer as well. I do work for private client. I do work for government as well. And we always settle things in an amicable manner. Whether I claim them or people claim against me, at the end of the day, we actually resolve it as what Oliver has said. The ultimate purpose is to complete the job.
Oh, that I think we seem to have forgotten. So very worrying words about the legal fraternity, Kevin, that lawyers ought not to be giving false hope. But I think the general consensus thus far that we've got is conciliatory. Would this therefore open the, is a highway for mediation? Is this really now going to be taking off?
I'm not sure if mediation will take off now, but if this entire problem continues and it does appear that it will continue for quite some time, I just don't think this entire problem is going to go away by the end of this year. We're going to have to live with COVID for the next 2 or 3 years. And if it does, then I do think mediation will become the dominant formal forum for resolving disputes, and you'll have less and less parties jumping into the other forms of seeking payment, whether it's by adjudication or arbitration. I see.
But it's encouraged under Section 9 of the Act 829, isn't it?
Correct. It is. But again, Section 9 uses the term may, so it's merely meant to encourage. It's there, but there's no actual requirement for parties to engage in mediation. But I must say this: a lot of employers and contractors are negotiating their way out of the problems that they are in right now, whether by formal mediation or not. And I do see that with assistance of their lawyers. I do see that. I'm sitting on the other side of disputes that are brewing, but both sides and the lawyers are trying to see if they can resolve it. What I do also see is there's a lot of, maybe not last year, but more so now, a lot of contractors are suggesting at the outset, look, give me my EOT, don't hit me with LED, let's finish the project on a no-cost basis for the LED. I will manage my costs, but let's just complete the project, don't hit me later on. And I see that more and more coming now.
Tan Sri David has posed this question. Should we then make it compulsory, mediation?
As a prerequisite?
Before you go anywhere, taking cognizance of, all these problems, these concerns, how we all interplay with each other, and the interlocking chain that Raj talked about, that a wise minister labeled it. So should we make it compulsory, mediation?
respectfully, I don't think we should force mediation on the parties. Mediation, by its very nature, is voluntary. It's not meant to be forced upon any party. But I think there should be greater processes and greater efforts to encourage mediation. And I think it should start with the courts.
I see. But that's already with the problem getting into the court. Right. But related to this, Raj, one of the participants has asked, would this be the right time, listening to everybody's concerns, is this about the right time for third-party funding then?
Yeah, I think third-party funding has its place, but I don't think it has a place in this particular situation. Because the thing is, all that's going to do is fuel confrontational resolution. Because a contractor who couldn't afford the cost of legal costs or the cost of arbitration will go to a third-party funder, and he will then be able to generate that litigation, and it is just going to it's going in the opposite direction to what we want, which is more an equitable sharing of costs, And interestingly enough, the question before was, is this the time for compulsory mediation? But again, taking a leaf out of Singapore's book, the Act actually talks about co-sharing of costs. And this is actually imposed on parties within, and there are certain limits placed on it. Initially, it was co-sharing of additional non-manpower related costs. And some of the additional costs that were mentioned were equipment rental, site maintenance, storage of materials, insurance premiums. And the COVID-19 Act in Singapore provides for the co-sharing of these additional costs incurred for the contractor. And it has to be, there are certain limits. The percentage is 50% of the qualifying costs, subject to a monthly cap, and a total up to a certain percentage of the contract sum. And there are certain exceptions to the rule. It doesn't apply to individual people. And then recently there was an amendment to the Act because they said that manpower costs had gone up by 40 to 60% in Singapore. And so now there is an amendment to allow for more equitable sharing of the increased foreign manpower costs arising from COVID-19. It was in that context that the minister made this point, the quote that I mentioned earlier. So originally it was for non-manpower costs. Now it's been extended because what has happened is in Singapore, they've now closed the door on foreign workers coming in, and the existing workers, the costs have gone up by 40 to 60%, and that's a huge spike. And from what Oliver said earlier, we are seeing a spike of somewhat similar order as well, So I think that the answer to it is not so much, because it doesn't cost the government anything. It's just, in a way, imposing within limits the parties to equitably share the cost, or co-sharing as they call it. And in New Zealand, interestingly enough, there is a charter called the Construction Sector Accord. It's not mandatory, but basically it is some kind of an accord reached between all the stakeholders in the industry, and there are guidance on. There is a guidance issued pursuant to that on allowing variations for this particular situation, but it is not mandatory. It is a directory, or rather, it is in the form of a guidance. So other countries are actually, the governments are stepping in to actually bang the parties' heads together to get them to share the costs, rather than wait for it to pan out in courts or in litigation or in mediation.
Right. So you have very wisely and done it so smoothly, Raj. It brings me to this question. We've talked about our Act 829, what's been happening. So is there adequate intervention from the authorities, including legislative support? It should more be done. We keep looking at other jurisdictions now. You tell us about New Zealand's charter and our neighbours' amendment on these costs. And we note what the authorities are doing as far as variation and price hikes are concerned. Should more intervention be expected and required from the authorities, particularly from the government, and in relation to the Act, or should there be something else? Raj, you're still holding the floor.
Yes, I believe there should be more. I think someone famously said at the end of last year, and we adopted his quote, it was, the Act was too little too late. I think, you know, and I think since then, there's been engagement with the stakeholders, and I believe Oliver and Dato have been involved with this for amendments to the Act, where, you know, the industry players put in all their inputs. But unfortunately, because of various reasons, including the fact that Parliament hasn't sat for a while, this has gone on to the back burner. But I think in due course it will come, as Christopher mentioned. You know, the wheels of government turn slowly, but they eventually get there. And I think hopefully we will get a more complete addressing of the problems, taking the local stakeholders' views into account. And
right. Thanks, Raj. At this point, what we're going to do, I mean, there's so many questions and comments, and we've tried to amalgamate it into our whatever thoughts we had on the topic that's been given to us. I believe we've substantially addressed concerns. We thank input that's been given by each one of the 1,300 participants at this moment. What I'm going to do is I'm going to put that poll out again, having heard the participants, having heard the remarks you've all been following on the chat group, and you've heard the sharing from these experts here. I'm going to put the poll out again. Let's see whether you have any different thoughts again. The organizers, having heard these experts and looking at the understanding now the magnitude in the other jurisdictions, do you all want to change your mind about the same poll? And this is the poll 2, same question. Who do you think should be responsible for the delay and the additional costs? Do you still want to, do you think that we should be giving you another box to say it should be all, or should it be a case of that your answer is still the same? Should we give you another box? And if you think we should give you another box where it is to be shared by all, reaching out a hand and holding that hand as far as we've been hearing, perhaps you don't tick any of that box at all. But if you still maintain your view, then there you are. I think what we should have done was to never mind, we'll keep it as it is. If you maintain your view, go ahead. But if you think, having listened to these esteemed speakers and sharing their experiences, the answer is not in any one of them, you know what to do, and still submit, is it? Can you submit? All right, we'll put it on for 2 minutes only this time, and let's come back to, you want another box. The organizers, can we actually put another box in immediately? All right, well, before they can answer, I don't think.
I think, Huyen, you are muted. Are you saying something to us?
Yes, I was wondering whether we could put another box in.
You're muted. You're muted, Huyen.
Am I still muted?
No, that's okay. I think it was Huyen's picture came up and she was saying something, but we couldn't hear her. She was muted, I think.
Right. We'll see what the reaction is. Let's come back to our issue. So, listening to what we've got this morning, is the solution at the end of the day a legal one somewhere inside the contract, or actually it's back to the persons who signed those contracts, and you don't look elsewhere because it really starts with yourself. So it's not elsewhere taking the blame, but everyone taking the blame. What say you? Can I start with Oliver?
Yeah, I think it's definitely absolutely sensible to look into mediation now for both parties. And this is the best way because both parties having a common objective, common interest to resolve the issues. and be sensible in certain sense. This is only a commercial decision rather than contractual dispute. So I think I would really recommend my fellow contractor and hopefully the developers look into the possibility of talking and negotiating rather than starting another painful journey at arbitration or court. That's what I think.
Thank you. Dato so.
I maybe just want to quote the BIPC declaration for those who don't have access to it. Actually, the statement say, COVID-19 pandemic is an unprecedented global phenomenon, and we hope contracting parties to approach all projects with a fresh mindset by looking at how best to preserve each other's interests as opposed to insisting on strict contractual rights. And consultants are encouraged to play facilitative roles in helping the contracting parties to explore options that will seek to balance their respective interests to ensure the sustainability of all the stakeholders and the building industry as a whole. Asking everyone to come to use their common sense approach and to share the burden equally, rather than putting all the blame or putting all the costs onto one party. In fact, during our submission to the government, we even magnanimously, told the government that you need to grant certain fixed period of time to the contractor, and also if costs, what are the costs that should be shared or to be borne. But sadly, nothing came about. And now the new problem that we have is that COVID 829 bill is only good for events or for contracts signed before the 18th of March 2020. What about contract signed, say, in October, November? And now we have got new movement control order, 2 months, no work. What is it? So a lot of, I think, contracting parties are now getting a bit uptight as well, given that nothing is done. We have just kicked the can down the road by extending the part 2 of the COVID bill to 31st of December. So we hope government listen in, and government should take proactive steps to actually do what is required.
Thanks, Dato. So, Chris, what do you think? The solution?
Judge, the solution is there's no right or wrong answer for contracts. It's all about, it boils down to risk sharing. In terms of an idealistic world, of course, you look at contracts. In reality, you heard the clients, the contractors, the developers, employers. They believe that mediation will work, whether it's compulsory, whether it's voluntary. It actually begs the question. At the end of the day, we need to resolve our differences to move forward. And the question you mentioned earlier about third-party funding,
yeah,
a client went to get third-party funding, but we haven't got any data, so it's going to be very difficult to actually convince a client to use third-party funding, because you're adding more as a fuel to the fire, and it's actually creating more situations. So I agree with Raj.
When you talk about third-party funding, it just reminded me of an experience I think was shared during our pre-con meeting. The Middle East, one of the jurisdictions there, the banks, we forgot to mention the banks here, the banks who are sitting and in a very advantageous position for, as far as some people are concerned, they have stepped into the role of playing third-party funders. That's for another day, gentlemen. That's for another day, perhaps for another discourse. Kevin, what do you think? Is the solution a legal solution or within the contract?
I don't think there's a clear legal solution, at least for now. Neither party is to blame for what has happened, what's happening, and what will probably happen for the next 2 to 3 years. We cannot attach blame to either party. The only question now is how do we apportion costs and how to stay afloat and ensure that the project itself is completed.
Okay. Right. Time is running out, and Raj, what do you think quickly?
Yeah,
and I'm going to just...
I agree with Kevin. I don't think that it's a legal solution. I think government has to take a more interventionist role because if you're going to leave it to the goodwill of parties, you might have responsible employers and contractors, but you also have other people who would try to profit out of the situation. So the thing is, you need somebody who's the government, in whose ultimate interest it is for projects to be completed, and for life to go on. So I think.
Thank you. Yeah, that's right. Let's have a look at the poll result, whether your sharing has made any difference. What you've done is you push the responsibility to 77%, and the employers have come down from the earlier 40% to 18%, and contractors even less. So folks, I don't know. This is, the result of your sharing seems to have convinced everyone that we need to turn to the government for a lot of solutions. Folks, there isn't time anymore for me to invite. I think that last question of us have let us direct our minds to the very real problem. At the end of the day, it's not a single set of shoulders. Let it be all, let it be sharing. Government's going to pave the way. Right, thank you, gentlemen. It's been an honor, it's been a pleasure. Have a good day, and thank you very much. Back to you, organizers.
Thank you, Judge.
Thank you.
Judge. Thank you for joining in the first show of the charity premiere. We have 9 other shows to go, and we urge you to sign up and contribute to the charity premiere. 100% of the proceeds will be channeled to our CSR partners. Tomorrow's show will be our panel of experts discussing about the legal ramifications and fallout from some recent decisions in the Apex Court. Thank you for joining the Director's Cut of the Construction Claims and ADR Conference, and a very good night to you.
And none of us are perfect and infallible, and so our decisions may not be perfect and certainly not infallible.
If now he completely forgotten about his basic contractual principle, then how are we going to challenge that award?
If the employer goes into liquidation, all of that money goes into the hands of bankers to fatten the bonuses of the bankers who already earn far too much money.
So up until today, although Bauer was reported in 2021, up until today, I think we're still dealing with the aftermath of Bauer.
At the end of the day, all you're entitled to is a reasonable compensation for your actual loss.